Good morning, everyone, and welcome back to the last session on polity and constitution. I hope I am audible as well as visible. Okay, uh, bestie, sir, special majority. Yes, 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 bestie. Vijay Raghavan, sir, give me single line advice to stop procrastinating on answer writing. Uh, 2 points. Number one, without answer writing, this exam will not be cleared. Period. And number two, parents are putting in lot of money or have put in lot of effort. So we can do at least this much. If not for yourself, for your parents. Yes, Parshuram, members are different, of course. These are three separate commissions formed at separate points of time. So members are, of course, different. Okay, so let's begin now our discussion for the day. In the previous class, we had covered a lot of ground with respect to fundamental rights. Of course, we finished a small topic called financial issues between center and states, and then Articles 12 and 13, and then Articles 14 to 18 and 19 to 20. Right. Today we'll continue our discussion from Article 21, that is right to life. We'll finish fundamental rights. We'll then move on to discussing DPSPs, fundamental duties, official languages, and preamble, and then summarizing our discussion with the salient features. That would end our discussion on the subject Indian polity for UPSC. Okay, so let's begin now with the standard 5 questions for the day. 5 questions in front of you. Okay, so firstly, it was incorrect, not correct. So, which statement is incorrect? Did everybody see this word incorrect? Okay. The speaker can only act on complaints and cannot take suo motu action on anti-defection law. This is absolutely correct statement. Yes, somebody has to complain. Number two, the whip is a constitutional office mentioned under the 10th schedule. A whip is not mentioned in the constitution. We had discussed this earlier that it is not mentioned in the constitution. It is borrowed from UK and is a post that every party has. Of course, neither a constitutional or a statutory post, the post of whip. So 2 is wrong, hence B is the right. answer. Moving on to the next question, question number 2. Please solve this question. Okay. The remuneration, the salary, the allowances of Attorney General are determined by the President. That's correct, of course. Right? The government determines it. It is not charged on the CFI, etc. Nothing of that sort. So, one is correct. The Advocate General of a state is assisted by Solicitor Generals are at the central level. And they assist the which person? Attorney General of India, not the Advocate General. So 2 is wrong. Right answer is A, 1 only. Okay. Then, moving on to question number 3, a topic we saw yesterday. Maybe slightly difficult, but if you apply some common sense, you might be able to solve it. Okay. Surprisingly, a lot of you have marked fundamental rights also as a part of basic structure. But basic structure can't be modified, right? And the same goes for fundamental rights. The fundamental rights can be modified. The fundamental rights have been repealed also, right? The essence underlying rights, I think I mentioned this very clearly, right? The essence underlying the rights cannot be modified, but rights are open to modifications. So 3 cannot be a part of the answer. Okay, so B and C are both wrong. Now, rule of law is a part of basic structure. Nobody can have arbitrary powers. So 4 is correct. This means this has to be the right answer. Welfare state, separation of powers, parliamentary democracy, all are a part of basic structure. Okay. Moving on to question number 4. I'll give you a minute to solve this question. I hope we all saw this. Incorrect. So, disqualified legislators can never contest an election. Can never. This is wrong. We have never seen this kind of provision. They can contest elections. It is all subject to one point. And what is that point? The point is that depending on the type of disqualification, it can be 6 years, it can be maximum 6 years, it can be 3 years, it can be 5 years. One is wrong. Disqualification cannot apply if the offense is a petty offense inviting punishment of less than 2 years. Yes, for petty offenses, right? When the punishment is less than 2 years, no disqualification. And offenses mentioned in section 8.1 of RPA will invite disqualification even for conviction without sentence. Yes, 8.1 is that section where disqualification happens whether you are given jail sentence or not, right? So, sorry, my bad. This is a correct statement, and this also is a correct statement. So, how many statements Ginaba are incorrect? Only one is incorrect. Arun, please locate the answer. No, that's not in my control, Arun, firstly, number one. And number two, is the question not visible? With the poll. Are you clear, firstly, guys, on this? Some are saying it is clearly visible. Then Arun, I think you'll have to either increase or go to the landscape mode or go full screen and stuff, right? Anyway, that is not in my control. I cannot move that poll thing. Last question. I will not launch the poll. You find out the answer, right? And then I launch the poll for 10 seconds. Okay, guys, I'm launching a poll now. 15 seconds of time. Mark the answer. One only, two only, both one and two, neither one nor two. Okay, great. So, the judge of Supreme Court or High Courts, an advocate having 10 years of practice in a High Court, of course, can be appointed judge of the High Court also, Supreme Court also. One is correct. A person who is a distinguished jurist. Now, please tell me, distinguished jurist is a criteria, is an eligibility criteria for appointment to which court? Tell me. Of course, only to the Supreme Court, not to the High Court. So 2 is wrong, hence A, 1 only. Clear? That's it. We are done with the questions for the day. Now let's move on to discuss our fundamental rights. Back to our rights, Article 21. This is the, oh, only one person got all correct. Shahid. Then Naveen, Kirti, Ayman getting 4 correct. And then Pradeep, Satish, Vanita, Himadri, Kambapati, Nikhil, Parshuram getting 3. And then others getting 2. Okay. So that's it. Let's move on now. Article 21. The right to life and personal liberty. So this article says it offers protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. So, save as in this procedure established by law, no person will be deprived of his or her life or liberty. Meaning, your life or liberty can be taken away. Yes or no? Your life or liberty possibly can be taken away, but only after following a procedure. So, this is there. Now, my point is very simple. What is meant by this procedure established by law? See, this concept of procedure established by law is borrowed from Japan. Okay. Now, what happens is, if I ask you, what is the, please tell me, what is the first thing that you do in the criminal justice system? Tell me, what's the first step in the criminal system? What is the first step that you do as the executive, as the law enforcement agency, etc.? Wait. The first step as an executive is to do what? Prevent a crime, right? Prevent a crime. Please don't be so angry. FIR, arrest, etc. No, no, no. Firstly, prevent a crime. Your task is to prevent crimes. But if crime has been committed, then what happens? Then you do a preliminary inquiry, a basic inquiry on what exactly has happened. Then you make some possibly FIR plus make some arrests, right? You further conduct investigations and file charge sheet, right? So then once charge sheet has been filed in the court, then the matter goes to court. The matter goes to court. In the court, trial takes place, where it's your task to establish the guilt of the individual. Then, after trial is over, verdict is announced, and depending on the verdict, if you are rich, you are acquitted. Sorry, if you are not guilty, you are acquitted. And if you have committed a crime, you are convicted, held guilty by the court, and then ultimately some kind of penalty or punishment is imposed. That could be fine or jail or both. Okay. So this is the entire procedure. You start by preventing crimes. Then a crime is committed. Somebody informs you. Your task is to firstly inquire. Don't jump to make arrests. Firstly, you have to verify whether the crime has actually been committed or not. Right. Then after basic inquiries, you can file an FIR, make some arrests also, and then further keep on collecting evidences and prepare a list of all the laws the person is supposedly has broken. Charge sheet. What are the charges against an individual? So maybe somebody has kidnapped a person. So charge of kidnapping, maybe charge of theft also, charge of assault also. So these are all various sections of IPC. So charge sheet comprises of all the allegations that the police is leveling against an individual. And this is presented in the court. And then the court asks the police, come on, prove it. You are saying he assaulted? Proof. You are saying he stole a car? Proof. For every charge, you have to submit evidences. Are we clear? Everybody, Arun, Shahid, all okay? So, my point is, think of this situation now. This entire setup has to be followed, come what may. And if we follow this procedure, we can kill you also, death sentence, or we can give you a jail sentence. Your life and liberty can be taken away. But this procedure must be followed. Whatever is the procedure established by law, that must be followed. Are we clear? Everyone. So it is very, very important to understand that in certain situations, or in almost every situation, executive action cannot be random. The police cannot directly arrest you and punish you. Your crime has to be established. This procedure has to be followed. Procedure which has been established by law must be followed. Meaning what? Executive action cannot be arbitrary. Procedure must be followed. Procedure must be followed. Did we all understand this point that executive action cannot be arbitrary? Procedure has to be followed. This is what is called the procedure established by law. So your life, your liberty will never be taken away without following a procedure. So this must be followed. Okay. But there's a small point. Just to extend this idea, let us say that a law is made. Law is made by the parliament. Law says anybody wearing a dress like this will be given a jail sentence of 10 years. This is a law which the parliament has passed. Let's assume, right? This is Ranveer Singh. He's known for his amazing uh, dressing sense. But anyway, if this is a law which has been passed by the parliament, my point now is law is passed. The police, the law enforcement agencies, the government, their task is to spread information. Guys, please don't wear this kind of dress. It can call for a jail sentence. Okay. But let's say somebody here loves to wear these kind of dresses, wears a dress like this. What happens? Then the police will get information that, oh, he's wearing a dress like that. The police comes, conducts inquiries, arrests you, files an FIR, right? And then collects evidence, photographs, Instagram posts, everything collects against you and takes it to court. In the court, evidence is found to be correct, and then the court punishes you with 10 years of jail. Did we follow the procedure properly? Tell me. Yes or no? We have followed the entire procedure properly. But tell me, arresting somebody for wearing a dress like this or punishing somebody, is it justified? Tell me. Whether somebody is wearing a dress like this or no dress at all, we don't care, right? So the problem here is not the procedure being followed. The problem here is the beginning only, the origin. The law itself is bogus. This law is wrong. So if the law itself is wrong, even if you follow procedure, then what's the point? Right? So in 1978, the Supreme Court actually tried to come up with this idea only that, see, procedures are being followed is very nice, but we also should understand that the law that is being implemented on people, that should also be logical, right? So the law must be reasonable, fair, just, rational. Law must be reasonable. You cannot make any random and arbitrary kind of law and force it on people. So law must be reasonable, law must be rational, law must be fair, law must be just. So due process of law means, or due process means, we will check whether the law is correct or not. Forget the procedure, that comes later on. Think of it. You are preparing for UPSC and you purchase a wrong book only for UPSC. And then start studying very nicely, diligently, everything. The procedure of studying comes later on. The purchase of book only was wrong. You purchased the wrong book, right? So when you purchase the wrong book, then even if you follow the procedure of studying it properly, the result is not going to be in your favor. Here, the same thing. If the law itself is wrong, then whether you follow all the process or not, it does not really matter. Are we clear on this? This is called due process. This has actually been borrowed from USA. Okay, and this is where we have to ensure the idea of being fair, right? Because it's very important that there is fairness, extremely important, because whenever you make laws like this, you are just being unfair. You are just being unfair in the sense that when you apply such laws, this makes no sense. It is very bogus, it is very stupid, and the application of such laws will only result in what? Will only result in uh, people just being treated in an unfair manner. Despite you claiming that, see, I am following what you may say as a proper procedure. That is why it's not always the procedure that matters. Sometimes it is also how you are applying the law that matters. Are we clear, everyone, now? I hope there is no doubt, no concern, right? So, fair application of law is very, very important. Okay, and for that the law has to be fair. For that, justice should be done, right? But fair application can only be done if the law itself is fair. So we say it is all about fairness of the law. Clear? Come here. This is fairness in application of the law. Fairness in the application. This is fairness in the law itself. Two different elements. Both need to be incorporated. Law is genuine, its application is genuine. The application is genuine, procedure established. The law is genuine, due process. That's why we say principle of natural justice. What is that? Fairness. So when you say that we have the concept of principle of natural justice, it is nothing but just saying that we want fairness of law. Law must be fair. Are you clear now, everybody? So this is due process and this is procedure established. In fact, for a large part of the first half, from 1950 to 1977, Supreme Court never went into checking whether the law was fair or not. It always used to check whether the procedures have been followed properly or not. It was in the Menka Gandhi case that Supreme Court for the first time incorporated this element also. That no, due process also must be checked. Article 21, even though it is not mentioned here, but it now includes, because judiciary cannot make a change in the article but can interpret it. So now Article 21 is interpreted to also include due process and not just procedure established. Okay, that's it. This is Article 21. And the beauty of Article 21 lies, I think we explained this point even in our discussion on activism. That the beauty of Article 21 lies in the interpretation by the Supreme Court. It has widely interpreted Article 21. Article 21 now means so many things. It is not just right to life and liberty. What is this nonsense? Just living, just surviving. Is that right to life? No. It means way more than that. So, right to live with dignity, right to decent environment, right to livelihood, right to privacy. The very famous Putta Swami case of 2017, right to shelter, right to health, Mohinder Singh Chawla case of 1997, right? Right to free education up to 14 years. So originally this was the Unni Krishnan case. Later on, it became a separate fundamental right. We'll see that shortly. Then right to free legal aid, right against solitary confinement. Remember this judgment? Shatrughan Chauhan. Then right to speedy trial, right against handcuffing, right to timely medical treatment, right of prisoners to have necessities of life, right of women to be treated with decency and dignity, right not to be driven out of the state, then right against public hanging, all such things, right against inhuman treatment, right against delayed execution, right to travel abroad. The Menka Gandhi case, where her passport was impounded, right? Right against bonded labor, right against custodial harassment, so many things now, right? Right to information, right to reputation. This was a case, Reliance Petrochemicals case. Versus Indian Express, 1989. Right to reputation. So yesterday we were discussing about defamation, where I said that Supreme Court upheld that right to reputation is a fundamental right, and it is a duty of the state to protect the reputation of all its citizens. Right against bar fetters. What are bar fetters? These are bar fetters. Different types of bar fetters. Like this is a cross bar fetter where your legs are also attached. These are chain fetters. Okay. So right against bar fetters. Right to sleep, which some of you do enjoy in the class, right? Right to electricity. Right to marriage. Hadia case of 2018. Right to freedom from noise pollution. Right against sexual harassment. Right against sexual harassment, meaning now sexually harassing somebody is violating their right to life. Mudrika Singh, just a couple of years back, 2021. So these are all a part of Article 21. Solve this question. A very, very difficult question. I'll give you 30 seconds. That's also too much. But still, mark the answer. Of course, right to privacy is a part of Article 21. Solve one more question. Okay, some of you are, I think, deliberately marking the wrong answer, but I'm not sure. How can you still be wrong? Article 21. Solve this question. Let's see. Done? Okay. Of course, Article 21. Right to privacy. Part of Article 21. Clear? Okay. So this question was asked this year only in the main examination. The Constitution of India is a living instrument with capabilities of enormous dynamism. The Constitution of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for a progressive society. Illustrate with special reference to the expanding horizons of right to life and personal liberty. Now, one statement that we will discuss later on is this phrase living instrument. So, Indian constitution is organic in nature. It's a living instrument. It's a living document, meaning it keeps on evolving, it keeps on growing. There is scope for growth and change. Hence, a living instrument, right? And it's extremely dynamic in nature, made for a progressive society. So, with reference to life and liberty, please explain this statement. So, basically, talk about in the intro, mention how it is a dynamic document, how it is a living document. Mention that, right? Talk about how it is not static, but rather evolves over time to meet the changing socio-economic circumstances. And the courts can interpret the various provisions, right, in the light of the emerging social trends, economic trends, cultural trends in the society, and then mention examples. So in the body, talk about firstly, write about what is Article 21, just to clarify the main provision that no one shall be deprived of their life or liberty, etc. Mention that. Okay. And then talk about various areas where the court has interpreted this Article 21, and then talk about this phrase expanding horizon. Where is it? Expanding horizons. Expanding horizons. So talk about expanding horizon. So here you can mention as many things as you know, right? For example, talk about how dignity has become a part, right? To live with dignity. Health has become a part. Privacy has become a part. Are you getting this point? We just saw all these elements, right? Clean environment, sexual harassment, things like clean environment, right against sexual harassment. The more you can remember, the better it is going to be. Right to education, right to livelihood, right against noise pollution, right to healthy environment, uh, clean environment is mentioned. Then right to marry, all these things, right? And then in the conclusion, talk about how, again, the various needs of various sections of society are being incorporated in this particular constitution, because it has this ability to adapt to the evolving needs of a progressive society, right? Through judicial interpretations, the scope of right to life has been widened now, right, including various elements. This makes a constitution not just a document of laws, but a framework of social justice and human dignity, right? And frankly, that's a reality, that this is not just a rule book. It is actually a framework for social justice, equality, egalitarian society, and human dignity. Did we understand Was this not an easy question? Straightforward, not complicated at all. You had to know all these elements and points. That's it. Are we clear? Should we move on now? Pooja, MKSS case. Are you talking about the Mazdoor Kisan Sangathan? That is not a case that they have filed. Actually, originally, this case judgment came in 1975, then 1988, and an organization, Mazdoor Kisan Shakti Sangathan, worked towards a movement to force the government into giving the RTI for us. So there is no case as such for them, but their contribution is there, of course. So with respect to giving us the Right to Information Act. Okay. Now coming to Article 21, capital A. Article 21, capital A, it has been inserted later on. So it was not there originally. It has become a part of the Constitution through 86th Amendment Act, that is right to education. And what is that? The state shall provide free and compulsory education to all children between a certain age, 6 to 14 years, in such a manner as the state may by law determine. What is by law? Again, same point. This article is an example of a non-self-executory article. When you say the state will make a law to provide for education, so as of now there is no education. We will make laws to provide for it. Clear? So a law was made, and that law is called the RTE Act, the Right of Children to Free and Compulsory Education Act 2009. This law was passed, right? And it provides for education of kids in the age appropriate classes for kids between 6 to 14. Okay. Article 21A, right to education. In fact, just to point this out, through this Amendment Act only, this Amendment Act, three changes were made. Originally, this particular provision was a part of DPSPs, Article 45. So that was changed. A new article was added. So fundamental rights were modified. Point one. Point two, DPSP Article 45 was also modified. Now it mentions provision for early childhood care and education. We call this ECCE. I hope you know that in today's day and age, kids are being sent to school at the age of 3 years, 4 years, etc. Right? Play school is what we call it. It's just one more way of earning money also for private players. Government schools start from class 1. So now the next target of the government is to also provide for ECCE, early childhood care and education, to children below the age of 6 years. Okay, the state shall endeavor to provide ECCE for all children until they complete the age of 6 years. And one more duty was added, a fundamental duty, the duty of every citizen of India who is either a guardian or a parent to provide opportunities for education to his child, or as the case may be, ward, between ages 6 to 14, of what? Education. So right to education is a fundamental right, and it's also a duty of every citizen who is a parent or a ward, meaning caretaker for a kid, to ensure that those kids go to school, the kids between 6 to 14. Okay, that's there. Now coming to no Parshuram, that is not a part of this article per se, but yes, under DPSPs we are trying to make that also a place where some kind of play school concept comes up, which is similar to what we have in the cities and urban areas. Now, Article 22, protection against arrest and detention in certain cases. So, next time the police arrests you, you have three rights, three fundamental rights. Are we clear? Three fundamental rights. You please tell the police that this is my fundamental right. Sorry. Right number one, right to be informed of the ground of arrest. When the police arrests you, you tell them, tell me, why have you arrested me? What's the crime I have done? Tell me. They may slap you, but polity wins. You know very well. Okay. Second thing is right to consult a legal practitioner, meaning right to consult a lawyer. So next time the police arrests you, you tell them, I'll talk to my lawyer only, nobody else. I want a lawyer. So don't call your friends, call a lawyer. That may be of bigger help. And number three, right to be presented before judicial magistrate within 24 hours. When the police arrests you, they cannot directly send you to jail and all. No. Or they cannot keep you arrested. They have to take you to the court. The judge will advise or award or order further arrest or bail. Are we clear on this? Everybody? These three rights available to every individual. So next time the police arrests you, what you have to do. Firstly, don't do things that the police will be forced into arresting you. But if it happens, please follow these things. Now, this right is not available excluding journey time, sir. Arun, excluding journey time refers to the travel time. The police may take some time in taking you from the lockup to the court. That is called journey time. Okay. Akash, sir, if there is Saturday, Sunday, will police leave me? No, 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 no. If there is Saturday, Sunday, don't worry. The police has to get the approval from the nearest magistrate, judicial magistrate, that we'll present the person in court on Monday. Right? It's a mere formality. Yes, it is sometimes used to harass people, but yes, it's a formality. But yes, you have to get that approval also, that because the court is closed, we'll bring this person on Tuesday or Wednesday. Okay, that is possible. So, right to be presented before judicial magistrate within 24 hours, excluding the time it takes to travel from the police station or your place of arrest to the court. That time will not be added, of course. Clear? Now, this right is not given or is not available to people who are enemy aliens. Who is this person called enemy alien? Pakistani citizens are enemy aliens. Yes or no? Tell me. Okay. Deepak? What, sir? Pakistani citizens are not enemy aliens. Enemy alien has a definition. What's the definition? People of those countries with whom India is officially at war. Sendil, there is now officially a war between us. War between which two countries? No, there is no war. There is no war. Okay. Second is people who are arrested under preventive detention laws. What is preventive detention? See, in your childhood days, if you remember this, whenever your mom used to go out of town or maybe out of house for a few hours or days, she knew what you will do and how you'll behave. So she would thrash you beforehand only, beat you beforehand only, before she leaves, so that now you are calm and you are well behaved for the next few days, without even you having committed any kind of misbehavior. You are slapped and thrashed. What is that? That is preventive punishment. To prevent us from committing a mistake, we are punished beforehand only. So if there is somebody who is a history cheater, habitual offender, a person is known to make frivolous kind of remarks, right? The police may arrest you even before you have actually committed a crime, because preventive detention means arresting somebody in the anticipation of committing a crime. The other thing is punitive. What is punitive? Punitive means when you punish somebody, when you punish somebody after the crime has been committed, or you arrest somebody after the crime has been committed. So this is detention after crime. Are we clear? So basically the idea is very simple. Let us say you are a person who is known to give very insightful speeches which can create a certain level of animosity. You give hate speeches. Last time also gave a hate speech. Now maybe in your area there is some Hindu Muslim riot happening. The police knows, oh, this person, he will again say something which will just add fuel to the fire. So the police, before you can actually give a speech to public, will arrest you to prevent you from committing a crime. Clear? Okay. So this is there. So this is preventive detention, imprisonment of a person in anticipation of a crime. A crime has not been committed. You are being arrested even before the crime is being committed. Why will it be done? It can be done on various grounds. Security of the state, maintenance of public order, maintaining the supply of essential services, and also foreign affairs or security of India. And let me tell you, preventive detention has to be done through a law, because preventive detention is what? Limiting your rights. You are not being given the opportunity to be taken to court. You are not being told the reason for arrest. So when we are limiting your rights, we will have to do it through a law. So laws on preventive detention can be made by both center and states. Why center and states? Because preventive detention is under union list, entry number 9. It's also under concurrent list, entry number 3. That is why both the states and the center can make laws for preventive detention. Now what happens is, when you are, let's say the police comes and arrests you, the police can arrest you and keep you in the police lockup for up to 3 months. 3 months. It's possible. Now, within those 3 months, the police will take you to a judicial advisory board. This advisory board comprises of people who are high court judges, or people who have been high court judges, or people who are eligible to be a high court judge. Right? Now, this advisory board will look into the allegation of the police, why you have been arrested, what is the threat from you, what is the threat perception. After all, the police have arrested you because they perceive that you can be of threat to society. So what is that threat? We want to know. And based on that, if the advisory board finds merit in the police's allegations, it can further advise, okay, arrest, keep on arresting the person, and you will be under arrest only. Or if not, the advisory board can say, no, 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 enough. You take him to court. Let the court decide what is the problem. Don't arrest him further. So this can happen. Now, Parliament by law can decide this: further imprisonment. The time when the advisory board says, okay, continue with the detention, no problem, the Parliament will decide for how long will the arrest continue. and it is different for different laws. So the maximum period of arrest varies. Just to give you an example, the National Security Act, it allows for arresting people for up to 1 year. 1 year after advisory board has given further detention, you can be kept in a police lockup for 1 year. Public Safety Act, which is there in Jammu and Kashmir, Public Safety Act of 1978, it allows for arrests of people for up to 2 years. Okay. Now, in this duration of arrest, the PDL, meaning preventive detention laws. So people under PDL, they may be informed of the ground of arrest. But when will they be informed? As soon as possible. What's the meaning of as soon as possible? Can you please tell me? Tell me, guys, what's the meaning of as soon as possible? As soon as possible means never. If it comes to the government, it would mean never only. So when they feel it is an appropriate time, why will the police ever feel anytime is appropriate? So you will be in jail for up to 1 or 2 years also, and you don't know why. Also, you will be given an earliest opportunity of making a representation against the order. Earliest opportunity. When will this come? Never, frankly. So this is the law called preventive detention law, which is there in the Indian constitution. It's surprising sometimes that our country has such provisions in the constitution. Under part 3, the restriction is that you can jail people for up to 2 years without even them knowing what wrong they have done. And the police may not inform you the reason of arrest if they feel that by informing you the reason, it may negatively impact what? Public order. If by informing you the reason, the public order may be hampered, the police may never tell you why they arrested you. After arrest, 1 year, there's okay, go now. Out. Done. Simple. National Security Act. There are various examples of such laws in the country. Like Preventive Detention Act was there. It was over in 1969. Then MISA, the very famous law MISA, Maintenance of Indira and Sanjay, Maintenance of Internal Security Act was there. It was repealed when Janata Party came to power. It was this law only, MISA, which was used in emergency to harass all the opposition people. 36,000 people were jailed under MISA. Coffee Posa. Coffee Posa is a law for preventing smuggling activities. Then the National Security Act. It's not NASA, it's NSA. Then TADA, one more dangerous law, which was there. Then Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act. And then POTA. POTA is also repealed now. But sadly, the provisions are now added in UPA. Yesterday we were discussing the last few minutes of the class on Article 20, if you remember, and where I said that nobody can be forced into giving an evidence to the police. No self-incrimination. You have there is no force, right, on you. You need not at all give any kind of evidence to police. You need not confess to the police, right? And even if you confess to the police confessions are never admissible in the court. If you confess to police, the court will refuse it. Yeah, it's okay, we can't rely on that. in a closed room with the police as the authority and the person has confessed, how can you rely that it's true? What if he was afraid, right? But POTA was a beautiful law to harass people. POTA said that if the confession has been given in the presence of an SP ranked officer, people like you, IPS officer, that confession will be admissible in court. So, I mean, very strange. So, what if an SP is here? Can SP not get involved in brutalities? He also can do it. Same thing. I mean, why do we assume that an SP will not be involved in brutality? It's possible he or she can also be involved. So, POTA said that if the confession has been opted in front of a superintendent of police ranked officer or above, then that confession is admissible in court. Such was the provision of POTA. Anyway, the law is gone, and it at that point of time it is required also because of what we saw in our country. In 2001, the parliament was attacked. The mastermind was Afzal Guru, this fellow who was killed later on, or rather was given death sentence later on, right? The left-wing pseudo-liberals tend to believe that Afzal Guru was innocent, etc. He has confessed of everything with proper detail, everything. And still we want proof. What kind of proof will satisfy these left-wing liberals? Maybe if God comes down and tells them, then only. Uh, anyway, so this is Article 22. Solve this question, came this year only. Read the statements first. I'll open the poll later on. Fifteen seconds. I'm launching the poll now. Please mark your answer. Okay. So statement one is correct. According to the Constitution of India, the central government has a duty. Which article is this? Come on, quick. Don't waste time. Don't Google. Which article is this? Now I have no faith in the answer. Not a single person. Oh, am I audible, guys? No response whatsoever. Yes, no, nothing. I am feeling it. I'm not even audible. Okay. So, anyway, can somebody type yes or no or give the thumbs up? Because I feel that how can there be no response at all? Guys, am I audible? All of you, please type yes. Strange. Okay. No. Oh, we have a lot of response. Oh, I think had some issue. Maybe that is why I could not see the response. I was like wondering what happened. Why no response? Now it's okay. Okay, so this is Article 355. I hope I'm audible, visible to everybody. Article 355, and this one, the Constitution of India exempts the states from providing legal counsel. Of course, we have just seen that under preventive detention, they may not give you any legal counsel. Now, according to POTA, confession of the accused before the police cannot be used. No, it can be used as evidence actually. It is allowed. Only two are correct. But let me tell you, this third statement is very difficult to answer. Right now, I told you and you know. But teaching this in the class on a 20-year-old law is not justified. And nobody would study this. So this was mighty stupid of UPSC to mention this statement and then leave no room for any kind of elimination also. So before the police, Shahid, police would mean any police officer, right? So this statement, if the police means SP here, then the statement is wrong. So the statement has to be correct in all references. Then only it is correct. Are you clear? So yes, a difficult question, but now let's move on and discuss the next group of rights: right against exploitation, articles 23 and 24. Very simple, very easy articles. First up is article 23, right against, not right to exploitation. Traffic in human beings, begar, similar forms of forced labor, they're all prohibited, and any contravention of this provision shall be an offense punishable in accordance with the law. Again, example of a non-self-executory article. So, traffic in human beings. What's the meaning of traffic in human beings? What is traffic in human beings? Traffic in human beings means buying and selling of human beings. Begar, forced labor, they're all prohibited. Traffic in human beings, all these things. Okay, and we have laws also to prevent these kind of things. Bonded labor, BLA, it's called BLA, Bonded Labor System Abolition Act is there, or ITPA, Immoral Traffic Prevention Act is also there. This law was originally called Suppression of Immoral Traffic Act. Look at this, Suppression of Immoral Traffic Act. What's the abbreviation of this law? What is the short form of this law? Tell me. So because the short form of this law is SITA, SITA, that is why we had to modify this law. Are you clear? The name had to be modified. So traffic in human beings means what? Selling and buying of men, women, children, immoral traffic in women and children, including prostitution, slavery, and devdasi. What is this concept of devdasi? Devdasi refers to the idea, very age-old practice wherein the kids before attaining puberty, they were or the girls, they were sent to God. So they were married to God in the sense that now they had to devote their life to serving the needs of the temple, maintenance, upkeep of temple, etc. Right? Later on, of course, this became a source of, or this became largely uh, a cause of misuse by the upholders of religion, and priests, etc., would force themselves upon these women, and it resulted in a lot of allegations of sexual exploitation, which was largely true also. And finally, we said that this concept should not exist anymore, and we have imposed a ban on devdasis. So, dev dasi, right? Das and dasi, slaves. Dev is the Lord. So slave to the Lord, Devdasi. Anyway, one more point, begar and forced labor. What is begar? Compulsory work without remuneration. Your parents ask you, go and bring vegetables from the market, go and fill the fridge with water bottles. Begar. Okay. So now you know begar is not allowed. Are we clear? No begar. So next time they ask you to do something, tell them Article 23, I will not work. Now, you know what may happen in future when you make this statement. So I will not be responsible for the repercussions. Okay? Repercussions for you. But polity wins, right? So you can tell them. Or forced labor. Forced labor basically refers to compelling somebody to work against their will. Like some of you here are sitting because your parents have been telling you, please go and become something in life, clear UPSC. So you are doing forced labor. You have no interest in studying. You wanted to sleep late till the morning, get up, watch some Instagram or YouTube shorts, waste time, watch the match. But sadly, forced labor. What to do? In case your parents are forcing you to study against your will, you can tell them Article 23 is getting violated. Again, they may slap you and all. That's totally up to you. Okay. Just one point I'd like to make here. Nobody can force you to work against your will. Okay. No forced labor. No begar. Nothing. But state can. Your parents cannot. But the state can. Nothing in this article shall prevent the state from imposing compulsory service for a public purpose. Interesting, right? State can impose a compulsory service for a public purpose. And in imposing such service, the state shall not make any discrimination on the grounds only of religion, race, caste, or class. No discrimination on the grounds of religion, race, caste, or class. For example, what kind of service can the state impose on you? Classic example is conscription, military service. Do you know that some countries have compulsory military service like Iran, Israel, Cuba, Angola, Algeria, Chile? So this actress, Gal Gadot, Wonder Woman, she is a part of the Israeli forces. She was a part of Israeli forces, right? In our country, there is no such military conscription, mandatory service. Uh, Tell me something. Can the state impose mandatory military service for only Hindus? Tell me, yes or no? Okay, because religion not allowed, no discrimination. So can the state impose compulsory military service for only women? Yes, it can. Discrimination will not be allowed on the grounds of religion, race, caste, or class. It can be allowed on the basis of sex or gender. Are we clear? So it is possible tomorrow that the government can say or the state can say, come on, women go and fight, men go and fight. It's possible. Are you clear? But on these grounds, not allowed. One more thing, one simple point here. Compulsory service for a public purpose. Let us say you clear the examination and you're going to your interview. You have cleared the prelims, cleared the mains, all dressed up. Finally, for the interview, you have taken bath after 3-4 months, right? And now you're going for the interview. When you go to the interview, what happens? You're wearing your best possible dress and you're about to reach the UPSC building when a policeman stops you. Where are you going? and you are in full attitude. You say, please don't disturb me. I'm going for UPSC interview. Once I clear the exam, I'll become an SP, I'll harass you. He says, oh, so you must have read all the articles of the Indian Constitution. You say, yes, of course. Did you read Article 23? You say, yes, I know Article 23. No traffic in human beings is allowed now. He says, did you read Clause 2? You say, yes, I read Clause 2. State can impose compulsory service for public purpose. The police constable says, do you think I am part of state? You say, yes, you are a part of state. Article 12. We know that. Ajay Hasia case. You are performing sovereign functions. You are part of state. Do you think cleaning the drainage is for public purpose? Yes, it's a public purpose activity. The drains are clogged on the road. We should clean it. The policeman says, I'm instructing you. Compulsory service. Go and clean the drains right now. Right now only. Can this be done? And if not, why not? Can this be done? And if not, then why not? Why Article 21? No, Article 23.1 will get violated. State can impose compulsory service. No, 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 no. All wrong answer except one. This cannot be done because this compulsory service can be enforced only through law. The policeman is an executive. He cannot make a law. What he is giving you is an executive order. Compulsory service can be enforced only by a law. If a law is made by the parliament, then he can order you. But his order is not sufficient. That's the reason, not other reasons. Okay? Are we clear? Everybody? Nothing in this article shall prevent the state. State can impose compulsory service. Nothing will come in the way. Your freedom, your laziness. No, no, no. But the only logic is that you have to make a law for it. Khambapati, the only right answer. Okay, great. Article 23. Now coming to Article 24, right? A beautiful image of the progressive India where rich and elite enjoy playing golf and a poor kid watching them playing golf. Anyway, this is Article 24, prohibition of employment of children in factories, etc. No child below the age of 14 shall be employed to work in any factory or a mine or engaged in any other hazardous employment. Clear? So a kid will not be employed in any such place. See, again, there needs to be a law for this, and we have a law. The law is called Child Labor Regulation and Prohibition Act of 1986. But look at my question first and answer. Can you employ kids under 14 as a domestic servant? 10 seconds. A for yes, B for no. Can you employ kids under 14 as domestic servant? A for yes, B for no. No, we cannot. Not since recently, since 17 years only. Originally, this law banned the employment of kids in 18 occupations and 65 different processes. In 2006, the law was modified, and now kids were banned from being employed as domestic help, as servants in houses, roadside dhabas, tea stalls, spas, hotels, etc. Not allowed. And in 2016, finally, this law was again amended. In pursuance of Right to Education Act, you cannot employ any kid under 14 years anywhere in the country, in any kind of job. However easy the job may be, does not matter. Employing kids under 14 is a punishable offense, and the punishment for this is what? Jail. It can be from 6 months to 2 years of jail. And fine can be from 20 to 50,000 rupees. Are we clear on this, everybody? Now, there's a small exception also. What's the exception? The exception is that kids can be employed in audio visual entertainment industry, TV, cinema. So you have all these reality shows, junior dance, senior dance, sing junior, dance junior, whatever these shows are. Kids can be employed here. They can. Second is family run enterprise. So if let's say I have a vegetable shop, right? So I can employ my kids there, but that should not impact with their school studies. And here family is a very limited meaning. It does Family does not cover uncles, second cousins, fourth aunts, third daughter-in-laws, 14th son-in-law. No, 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 not that. Close members, mother, father, unmarried brother, unmarried sister, that's family. Are we clear? So only two exceptions: family run enterprise. If the family is running an enterprise, say maintaining a vegetable shop, etc., then the kid can work, but after school hours, not during school hours. That's it. And in 2016, one more change was made. The change was that we have a new category now called adolescents. Who are these kids? These are kids between 14 to 18. Okay. For adolescents, you are allowed to work, but not in hazardous occupations, which includes mines, which includes inflammables, meaning substances which catch fire quickly, which includes what? Explosives. In these three sectors, in these three industries, the kids between 14 to 18, adolescents, cannot be allowed to work. And it has an entire list of what these areas would comprise of. If you want to know the list, please download Factories Act 1948. In their Schedule 1, you have all these various kind of occupations like the paper industry, bangle making, coal, iron ore industry, all these sectors. Clear? Article 24. Solve this question, came in prelims 2017. Mark the answer. Okay, easy question. Right against exploitation, forced labor, Article 23. Untouchability is right to equality, not a part of the answer. Minorities, Article 29, not a part of the answer. And this is Article 24. So 1 and 4, C is the right answer. Okay. Still, some rural areas have children working in dhabas. See, guys, just to give you a simple pointer here, in case you ever find kids being employed somewhere, you please complain to the local police station, send an email to your city SP, or go on the Ministry of Women and Child Development website and lodge a complaint there with photographs. Don't take matters in your own hands. Are we clear? You are not the law enforcement agency. So don't try to be the savior you are not right now. You can complain. Be the informed citizen you are. It's a true story. It happened once. So I think around 4 years back, in one batch, I did say this, and this student came to me after a few days, maybe a few weeks of this class, and said that, sir, you said that we should complain. So I saw this 2 3 kids begging on the street. I caught them and told them, come on, come, I'll take you to the uh, nearest station. Who is harassing you? Who is forcing you to beg? And the kids started shouting, kidnapping, kidnapping, right? So please don't do all this. It can backfire. Are we clear? Kids under 14, small kids, they don't understand that it is for their welfare and all. Remember, you're also a kid. They don't have an understanding of what is good and what is not. So complain. That's it. Okay, that's all. Let's take a quick break. Be back at 11:45. A small break, and then we'll discuss the very dangerous freedom of religion. Break, please. Come back quickly, guys. Okay, guys, let's continue. Uh, Pradeep, 7 to 8 out of 15 is a pretty decent score actually. Just keep on writing more answers. That's it. Simple practice. Uh, After school hours, possible, it should not involve any manual labor, right? Oh, okay. Eman, is there any difference between liberty and freedom? Yes, of course. It's rather used interchangeably, liberty and freedom. But liberty refers to state of being free from any kind of oppression. That's liberty, right? Any kind of restriction, any kind of control. Freedom refers to this idea of being able to make choices free from external control. So that's where the nuanced difference lies. Kambapati, you'll be informed of this by the management, don't worry. Now, coming to Article 25 to 28, before you discuss the Article 25, that is the freedom of conscience and free profession, practice, and propagation of religion, coexist, coexist, right? Nice tattoo art. In case anybody is interested, it's a very good tattoo suggestion for you. Before we begin our discussion, one simple question, 10 seconds, A for yes, B for no. How many of you believe in God, spirituality, some form of supernatural power, some form of energy, etc., all in A? And if others, if there's somebody who believes there is nothing like this at all, zero belief in God, in supernatural, in energy, in this cosmic power, in this whatever, no belief, type B. Okay, there's no right or wrong answer. Why did some of you mark C? I left C deliberately so that I could choose C as a correct answer. Okay, so a lot of you believe, but there is no middle path here. No middle path. Either you believe in something or you don't believe in something, right? Okay, so a lot of you believe in some kind of God or some form of energy or some form of spirituality, etc., including those in following the middle path. You also are believers only. It's as simple as that. Okay. So let me just begin on a small note that if I say something which obstructs with your belief system, don't be angry. Your God is not angry. It's okay with God. You don't take the mantle of being angry on their behalf. Clear? We're having a discussion. Remember, discussions are always allowed. However annoying they are, however critical they are. Okay. So don't come after me running and kill me. Right? I have a lot of batches to take this year. Okay, so Article 25, freedom of conscience, free profession, practice and propagation of religion. Subject to, interesting. I mean, before I can read the article and what right I get, I am getting all these restrictions. I mean, look at Article 19 or any other article. Every article gives us some rights and then says, wait. With these rights, restrictions are also there. But this, where is the right? The article starts with restrictions only. Subject to public order, subject to morality, subject to health, and to other provisions of this part. Which part? Part 3. Meaning, all other provisions of part 3 are restrictions on this right. That is why we see that the Article 25 has been given the lowest precedence in the rights hierarchy. If you try to list the hierarchy of all the rights, Article 25 is the last, because every other provision of this part acts as a restriction on Article 25. Are we clear, everyone? Once you've understood this restriction, all persons are equally entitled to the freedom of conscience and the right freely to profess, to practice, and to propagate religion. Full right to practice, propagate your religion. Great, amazing, very good. Now, what is the meaning of all these things? Freedom of conscience. So, the idea is that you are free to mold your relationship with God in whatever form or manner you want to. You believe God is in the temples or mosques or churches, gurudwaras, place of worship. Good for you. You believe God is in books. Great. You believe God is in this country. You believe God is in your parents. You believe God is in somebody you love. तुझ में रब दिखता है. No problem. It's all your choice. You are free to mold your inner relationship with God in whichever form you want to. You talk to God, God comes in your dreams. We do not care. Second, you are also free to profess, proclaim your religion publicly. So there are various visible manifestations of how you proclaim your religion. Maybe a Sikh can wear a turban, a Hindu can wear a tika, a Muslim can wear a skull cap, right? That's all a part of professing your religion. Now, just a small point. In the constitution itself, it has been explained that the wearing and carrying of kirpan, so this is a kirpan, okay? So, wearing and carrying of kirpan shall be deemed to be included in the profession of the Sikh religion. Are we clear? So, your religion of Sikhism, whoever follows this, their practicing the religion, their profession of religion will include carrying a kirpan, a knife of sorts. It's not going to be an actual knife like a big machete or a sword, but a symbolic knife. So, in airports, in malls, in metros, etc., the Sikh person will be allowed to carry this kirpan because this is considered to be a part of their practicing religion, part of their profession of religion. Okay. Third thing is to practice. Practice means to carry out rituals. To carry out rituals, you are free to carry out your rituals. It should just ensure that it does not obstruct public order, morality, and health. That's it. Simple. Are we clear on this? And lastly, you have a right to propagate your religion, transmit your religion, spread your religion by spreading the doctrines, the tenets, the principles of your religion everywhere. You also have a right to spread your religion. Clear? So that was clause 1. Now comes the real provision here. Clause 2. So clause 1 gives us all these rights that we can enjoy. Clause 2 says nothing in this article shall affect the operation of any existing law or will prevent the state from making any law. So Article 25 clause 1 cannot prevent the state from making any law. Law on what? It will not prevent the state from making any law to deal with regulating or restricting any economic, any financial, any political, or any other secular activity which may be associated with your religious practice. For example, if some religious group wants to run a hospital. Now, there you cannot claim that I want to hire my priest as a doctor. No, no, sorry. Your religious preachers, they cannot conduct operation. They cannot conduct open heart surgery. That's not possible. So, if you are running some kind of a secular activity, a school, a business, etc., then the state can regulate it. The state can restrict it. Simple. If I today start saying that come to my place of worship and get your cancer cured, now the state can say stop this nonsense. That's not possible. Are you clear? Second, and very important, the state will make a law. Nothing can stop the state from making a law providing for social welfare and reform. If in your religious practice there is some element which violates the dignity of individual, which is against welfare, which is against a group of people, then the state can interfere and can make changes also, can make a law and remove that practice. You keep on crying, God has told me, state will not care. State can make laws to provide for social welfare. State can make laws to provide for reform, or the throwing open of Hindu religious institutions of a public nature to all the classes and sections of Hindus, meaning allowing temple entry. So, state can make laws to allow temple entry. And here, Hindus will mean not just Hindus, but Sikh, Jain, and Buddhist also. Are we clear? So, this was largely done at the behest of the makers of our constitution to incorporate the element where we saw that scheduled caste people were being denied temple entry. So it was largely done for that purpose only, that the state can make laws to ask you, come on, temple open for all. Are we clear? This is Article 25, Clause 1 and Clause 2. This is extremely important. It allows the Indian state to interfere in your religion. Clear? So don't claim absolute nature of your God. It is not possible. For social welfare, for reform, if the state feels you are violating public order, morality, health, or any other provision of this part, the state can make a law and say, sorry, extremely sorry, that practice will have to be removed. Now, just a small point, right to propagate your religion, right to spread your religion. Does it also mean right to convert? Or forget that? Answer a question. Should we allow right to convert? A for yes, B for no. A for yes, B for no. Should we allow the right to convert? Some would always mark C and D. I don't know what is the problem in marking A or B. Okay, a lot of you say yes, some of you say no, others we don't know what you say. So if you don't have opinion on anything, then it's very sad. Now, right to propagate and right to convert. Right to spread the doctrines of your religion everywhere. In the state of Odisha and the state of Madhya Pradesh, back in 1967 in Odisha and 1968 in MP, they made some anti-conversion laws that conversion will not be allowed. Okay, these two laws were challenged in the respective high courts. I hope you know that high courts also have the power to interpret the constitution. They were challenged. One high court, like MP High Court, it favored the law. Odisha High Court cancelled the law. Problem. Supreme Court. In the Supreme Court, Reverend Father Stanislaus, 1977, In this particular case, the Supreme Court gave a judgment, a 5-judge bench with A and Ray also there. Supreme Court gave a judgment that right to propagate does not include right to convert if conversion is obtained via force, fraud, or allurement. If your conversion is obtained on these grounds, then you do not have a right to convert people. So basically, what is meant by force? You forcibly convert somebody. Understandable. What is meant by fraud? How do you convert people by fraud? Or allurement? What is allurement? Luring somebody into joining your religion. What is allurement and what is fraud? Can anybody explain here? Giving money? Okay. Fair enough. Food, job, house? Fair enough. Love, jihad? Fraud? Fair enough. But don't you think that fraud and allurement are very vague terms? Right? When you are luring somebody into joining your religion, money may not always be involved. For example, have you observed all religions say the same old story? Right now, your life is not good. Join my gang, means join my religion. Your life will be amazing. But not right now, after you die. Right? After you die. Now, once we die, what is the proof? Right? Whether our life will be amazing or not. There's no life only. No religion can actually prove anything that they promise. That's a reality. I don't want to offend anybody, but it's your belief only, right? It's a belief. You believe in these things. So it cannot be proved by any individual. Now, some may say, sir, we may not have the senses to feel God. That's okay. Can be proved? No. So whatever I say in my religious texts, it's all a fraud only. It's all allurement only. If I today tell you, wear this ring, you'll clear UPSC. It's a fraud only. It's an allurement only. So practically every conversion is an allurement. After all, somebody is joining some group, right? Based on the doctrines only. Where is the proof? Kalyani, by doing some dhyan, we can know about the past life and future life. That's why I said, guys, that I can only talk on the terms of legality. Now, if something has not been proven, I may not be a very good judge of that, frankly. So, as I said, I don't want to affect anybody's belief here. It's your belief system. Again, as I said to Kalyani, you also, it's your belief. If I mention this statement and take a poll, a lot of you will not believe it. Simple. So, it's all about belief. Maybe it's correct, maybe it's not. I hope this is okay. I'm treading the right path of saying that you may be right, you may be wrong. The idea is you believe in it. Somebody does not. Right? Now, everybody believes in sun. Everybody believes that the earth is not flat. It's simple. Some things can be proved, some things cannot. When you can't prove it, it's just a belief system. Right? So the problem is that everything can come under allurement since there's no proof. So this judgment was very vague. Kalyani, now you're wanting to get into an argument on religion, which I clearly don't want to. If evidence exists, there is no categorical evidence which keeps on existing, right? One time occurrence is not evidence. We are talking about science here. Experiments. You drop a ball here or in your house, there is gravity everywhere. Or you drop a ball here today, you drop it tomorrow here, there is gravity. So if there is proper evidence, which means it can repeat again and again over a course of time with all the variables intact, then we feel that okay, it is correct. So partially available for somebody else in that particular position or situation only, that is not believable evidence. Please, let's not get into that debate. There is a no never ending debate on religion. Nothing can be proved, if I may say very, very frankly. So it's just your belief. I was just trying to be very nice, but things don't work like that. Maybe there is no proof of all this happening anywhere, right? So let's ignore that. Focus on what I'm telling you. That is more important. This is not a class on theology, guys. Please understand. It's a class on legal aspects. Remain here only. Your God is okay. He'll never be angry at me or you. Don't worry. So the idea is that this judgment is not appropriate. When you give this kind of categorical statement, that a very vague statement, that allurement should not be used, so practically you are stopping every conversion. Which means what? If I today read some Sanatan books and I'm inspired and I want to become a Sanatani, there's a problem. You may claim, oh, Sanatan books have allured you. If I read the Quran and I become very inspired and I want to become a Muslim, again you will say, allurement has happened. You have been lured. So how will I convert? So you are giving me a right, but am I actually able to enjoy it? No. So this is a big problem. And the judgment is so vague that it has opened this Pandora's box of laws across the country, anti-conversion laws. So there are states like Arunachal, there are states like Chhattisgarh, Gujarat, then we had UP recently. Various states, Uttarakhand, have made anti-conversion laws. Arunachal in 1970, Chhattisgarh in the year 2000, Gujarat in 2003, UP in 2020, Uttarakhand in 2018, Jharkhand in 2017, Himachal in 2019. So many states. And you'll be surprised to know that in these states, the provisions include provisions to convert, prior notice to government officials, government authorities or officials before converting. So if I want to convert today, I cannot convert today. I have to give notice 15 to 60 days prior notice before converting. And there are penalties and punishments also. Penalties and punishments for conversion, for abetting conversion. And this punishment can be jail term, 1 to 5 years. And this can be a fine also, which can be up to 50,000. Simple question. I want to use my freedom of speech and expression. With whom should I take the permission? Nobody. I'll use it. But to convert, which is also a fundamental right, I need to inform the government 15 days beforehand, 30 days beforehand. Why? Why should I inform? Today I want to be a Muslim, tomorrow a Hindu, day after tomorrow a Christian, then Sikh. It's my choice. No, no, no. It's not. It has to be documented properly. You have to take prior permission, etc. So that is it. And of course, mass conversions are punishable offenses. Mass conversions, there are penalties in states like UP, in states like MP for mass conversions. Largely, this is all because of the allegations against the Christian missionaries that they purchase conversions. There are allegations even against the Sisters of Charity, the Mother Teresa's organization, that they used to convert people in the deathbed also. You're dying, convert into my fold and then die. You'll have an amazing afterlife. So, and not made by Indians. Indians celebrated Mother Teresa, made by Westerners only, right? Christopher Hitchens, Richard Dawkins, so many such people Sam Harris have constantly made allegations against such organizations for just being organizations to convert people. Uh, there is no such proof of all these allegations, or at least I don't know of such proofs, though they give a lot of proofs which can be accepted also as very valid arguments. But for the sake of it, we don't really know. But yes, we do know that there are situations where people are given rice bags, people are given food grains, people are given money to convert. And that's the worst form of conversion. That you take the advantage of somebody's deprived economic circumstance, right? Economic circumstance, and then take the advantage of that person's poverty and force him to convert. That's worse. But anyway, all this is, of course, happening, and despite the provisions of these things there. So we don't really know whether this law, this judgment is valid also or not. Does it actually work or not? And as for the anti-conversion laws, the anti-conversion laws have been challenged. All these anti-conversion laws across the country, they have been challenged in the Supreme Court. But the matter is pending, like all other important matters. So there's a case Citizens for Justice and Peace 2020. So this matter is pending for 3 years. See, the only argument in favor of some provisions of anti-conversion laws, like giving prior notice, is to collect information and collect data. But for that also, people simply say that we can give notice after converting. Why to give notice before converting, right? If the government's task is to collect information and data, that will come in census only, right? So that we can give, and that can be given after conversion. But here, to convert, you are getting permission. It's like you are getting the permission from the government to convert. That should not be the case. I hope this point is clear. So anyway, this matter is beyond our discussion now because the matter is pending in the court. Don't expect a question, but if a question is asked in your interview, your response should be that we should go and now rephrase this particular judgment and try to define in exact terms what all things would allurement cover. We cannot use a vague word like allurement. We have to categorically define it, right? Okay. Now, moving on to Article 26. But before that, one small point. I think since all of you have been studying political theory, this book which I asked you to study, expectation. Expectation. I hope you now by now know what is secularism. See, this idea or this meaning of Eman, does leaving religion come under anti-conversion laws? See, if you want to get that officially documented, yes. Otherwise, no. So, conversion, especially with official documentation, would require information, right? Nikhil, even documentation is necessary for better policy formulations. Yes, yes, sir. Of course. We have seen so many policies which impact people of various religious groups in the country. That's true. What is secularism? It's a Western concept. This concept does not work in the Indic region because in India, as Loknath Mishra said, religion can never be divorced from life. So, secularism is a Western concept which actually means just one thing, very simple: strict separation between religion and state, church and state. That is called secularism. Strict separation between church and state. Now, this means what? This means that the state will not interfere in your affairs of religion. So, we are now delving into the Western model of secularism, which means non-interference. So, state will not interfere in your matters of religion. There will be no support from the state. There will be no hindrance from the state. You are free to practice your religion in your private space. Are we clear? No support, no hindrance also means that no protection to any group. If a larger religious group tries to overpower a smaller religious group, we cannot support you. Sorry, it's your personal drama. Do it at your personal space. This is Western model. Indian model is slightly different. Now we call this a more positive approach. This is a classic case of positive secularism, where the state has no religion. State has no religion. All religions are treated equally. But the most important point is that your freedom of religion, you can enjoy it, but the state can interfere. So in our country, the idea is that the state interferes. We call that principled intervention or principled distance. Both words would be correct. Meaning, state will interfere in your religion to prevent discrimination. To prevent discrimination. So we will say that we protect the religious freedom of all, minority or majority community. Everybody's religious freedom is protected. Are we clear? Everyone? Okay. So we can interfere in the religious matters. Sir, in America, two religious groups are having riot. Will government not interfere? If it's a public order issue, they will, but they will not interfere on the religious aspect of it. Nikhil, how can state which does not have a religion, which also means it does not have knowledge of? No, it does not mean that. If you are apolitical in nature, does not mean you have no knowledge of politics. It's just that you don't want to take sides. Simple. So, state having no religion does not mean the state has no knowledge of religion. Clear? Those are two separate things. Anyway, So this is what is secularism. For more details, please read this book, Political Theory, which you must be reading, I'm sure. Chapter 8. This chapter is on secularism only. Please read the chapter, you'll get information. I have just summarized the entire chapter, adding certain points here. That's it. This is secularism. Principled intervention, principled distance. And that's the advantage. In India, the advantage of our secularism is that if things go wrong in your religion, if you're trying to take away somebody's dignity, violate somebody's dignity, etc., then the state can interfere. If you are trying to follow some kind of ritual which violates life, liberty, etc., we can take away that power of yours or the right of yours to practice that ritual. That practice can be curtailed, your profession can be curtailed. It all depends on whether you are trying to follow your religion within the limitations created by Article 25 or not. Okay, that's it. Now, Article 26, the freedom to manage religious affairs. So, this is Article 25 was meant for individuals. As an individual, I have a right to practice my own religion. And Article 26 says my entire group, every religious denomination, every religious group has a right to practice its religion. Right, number one, to establish and maintain institutions for religious and charitable purposes. Okay. Number two, and very important, right to manage its own affairs in matters of religion. Right to move and acquire movable and immovable property. And right to administer such property in accordance with law. Keshwan Bharti case, these rights were being curtailed. That his land was taken away, his Article 26 was challenged because every religious group has a right to own and purchase property. So, interestingly, individuals in our country, we have no fundamental right to property, but religious groups still enjoy the fundamental right to property. But again, here also three limitations exist, not four, but three: public order, morality, and health. In the case of Article 25, there are four limitations: public order, morality, health, and all other provisions of Part 3. So that is not the case for Article 26. That is why Article 26 is superior to Article 25. Are you clear on this? Did we understand the statement I made? Article 26 is superior to Article 25 because Article 25 has a limitation that every provision of Part 3 is a limitation on Article 25. But there is no such clause for Article 26. Okay, that's it. Now, the issue of Sabrimala. So I hope everybody knows this entire issue of Sabrimala. Just to summarize it very quickly, Sabrimala temple is considered the abode of Lord Ayappa. So Lord Ayappa, and it is located in the Periyar Tiger Reserve, Western Ghat mountain range in Kerala. Now, there was a Kerala government rule, right? Kerala government rule in 1965, which stated that, or the rule was the one for the first time which created this situation where women of certain age group were not allowed. Prior to that, women in general were not allowed entry in the temple. But then the Kerala Public Worship Rules of 1965, there's one Rule 3B, which says that what? Which says that women between the ages of 10 to 50, they will not be allowed entry in the temple. So, the Kerala government public worship rules public worship rules. Rule 3B. Denial of temple entry for women between 10 to 50 years. Okay, this was the case. Now, in 1990s, only the Kerala High Court had upheld this rule as constitutionally correct. Okay, but in 2006, Indian Young Lawyers Association filed a PIL stating that this is excluding women. It violates the dignity of women. It violates Article 14 and Article 25. Why 14? Treating women and men differently based on their physical features in a temple. And why Article 25? You are not allowing women to practice their religion. Article 25. This matter kept on dragging in the court. Finally, in 2018, a judgment came on the 28th of September 2018. Judgment came. Supreme Court declared this entire practice of prohibiting women in their menstruating years from entry into temple. So women between the age of 10 to 50, because supposedly they are menstruating, these women were not allowed entry in the temple. So this practice is now deemed unconstitutional by the Supreme Court. Supreme Court gave simple reasons. Supreme Court said, and the judgment came with a 4:1 judgment, right? So reason was, number one, this kind of abhorrent practice is what Supreme Court called it, denudes women of the freedom of worship, meaning it takes away their right to worship. It also amounts to untouchability. Very strange, right? It also amounts to untouchability, meaning the idea of this untouchability, Article 17 was invoked, that you are trying to treat women as untouchables when they are menstruating. Wrong. And thirdly, state can bring social reform. Remember, Article 25, Clause 2. State can bring social welfare and reform. In fact, that is the crux of our secularism. Why do we have this kind of thing here? The source of this principal intervention is Article 25, Clause 2. Subclause B, that the state can bring welfare and reform. So it was said, it also said that, uh, it subverts the idea of dignity, liberty, autonomy, and it tries to attach a stigma to menstruation, which has no place in the constitution. So these were the reasons given, and women's entry was allowed. Later on, a review petition was filed. Article 137 allows for filing a review petition within 30 days. It was filed. That petition was pending for a long period of time. And then what happened finally? The Supreme Court said, let's do one thing. This is not a single issue. It is a larger issue now, where the denial of entry of women to place of worship is there. For example, Parsi women. If a Parsi woman marries a non-Parsi, she is not allowed to enter the fire temple. Or when it comes to the practice of female genital mutilation in the Daudi Bohra community. So all these things are now being looked into by a 9-judge bench. So a review petition is pending and has been transferred to a 9-judge bench to deal with a larger issue. Now, a couple of points. See, why was women's entry not allowed? Was because Lord Ayappa was following Nashtik Brahmacharya. Brahmacharya refers to celibacy. right? Celibacy. So he's a celibate lord. So women's entry was not allowed. And this menstruating women's entry, that was made by Kerala government, not by temple. Now, it denudes women of freedom of worship. So this point may not be a very strong argument because Article 25 versus Article 26, if you place this, so a woman's right or a man's right or any person's right to practice your religion, Article 25, place it with any religious group's right to manage their own affairs. If you try to place them in front of each other, then this article prevails because Article 26 is superior to Article 25. So, a particular religious group has a right to manage their own affairs in matters of religion. Second, it amounts to untouchability. Now, this is, I would say, very shady of the Supreme Court. They found a very cunning way to use Article 17. Article 7, Supreme Court said that Article 17 does not have a definition, which was deliberately done by the Constituent Assembly to include everyone. No, it was not. Are we fools? Untouchability was suffered by a community for generations. You cannot use this everywhere else. This is wrong. Please don't use the word untouchability everywhere else. There was a purpose, a specific reason for Article 17. We cannot simply make it generic, right? So tomorrow, if somebody is suffering from some disease, and can we invoke Article 17 there just because Article 17 is not defined? Think how silly it sounds, right? If today you are suffering from very serious cold and somebody does not want to sit in front of you, and then can you invoke Article 17? Untouchability? Of course not. Can you go to court and say, sir, it is not defined? Of course it is not defined. But of course we know the inherent meaning of it. So very bad on Supreme Court's part. I don't know what they thought that they invoked Article 17. And also, invoking Article 17 with respect to menstruation in religion, where one temple in Kamakhya, a Kamakhya temple, already worships this practice of menstruation. This whole story of Shiva and Shakti's body being chopped into more than 50 parts, one part falling into that region. So menstruation is being worshipped in the same religious fold in some other part of the country. So calling it untouchability is a bit far-fetched. Then state can bring social reform. Yes, we fully agree. State can. What is state? Article 12. What is state? Judiciary is not a part of state. Do you remember? Judiciary is not a part of state under Article 12. Then how can you, my lords, bring reform? That's where you failed to understand the complexity of this topic. That it is not under your purview and control. But what and how did Supreme Court derive this power? So there is a very old judgment called Shirur Mutt case, 1954, 7-judge bench. At that point of time, we only had 8 judges, 7-judge bench. So Supreme Court has given this judgment stating that uh, what is essential in your religion and what is not essential in your religion, we will decide. The court decides. Court. How does the court decide? So the court has said that we are going to decide which religious practice is essential, and only essential religious practices will be given the protection under Article 25. You have a right to practice your religion, but only essential things can be practiced. Non-essential things, you cannot claim Article 25. Are we clear? Now, court said we are going to rely on doctrines of religion. We are going to rely on evidences, people's behavior, practices existing since a long period of time. This cannot be a very good parameter to rely on what practice could be logical and what could be not. If you rely on the doctrines of religion, then all religious texts have been made in times which were deeply patriarchal. If you rely on people's behavior, if you look at, say, the Hindu, Sanatan, as now it is being called, there is nothing common in the way a Tamilian worships and in a way, say, a Bihari worships. Nothing common between a way in which a Maharashtrian worships or a Bengali worships. they have different practices of worship. Maybe the gods are same, but the names also change. So how can you find out one common essential practice? That's not possible. In one family only, there is so much of diversity in how you worship your God. Where is the commonality? What are you relying on? So this judgment is also not appropriate. And the bigger point is, do courts really have the knowledge of religion? Judges, they may be experts in the field of law, but for religion, they're not theologians. That's where there is a problem. That judges may not have the expertise of religion's knowledge. So terming something untouchability may not be appropriate. Beyond that, some people may also question that what is the locus standi of this association which filed a case. Largely, the association claimed in their judgment, in their petition also, that they are atheists who filed a case. So maybe as an atheist, they may not have an understanding of this religious practice. That's also possible. But anyway, the judgment is pending. Our conclusion is very simple. See, these things should come from Parliament because Parliament represents the will of the majority. Court should refrain from deciding on these matters. So, ideally, the Parliament should make a law on this matter. Allowing or not is best left for the Parliament to decide. And there should be choice. This is the whole problem. We are not giving people choice. See, there are a lot of women who may themselves not enter a place of worship if they are menstruating. Forget Sabrimala, other temples also, in your own house also. But the whole idea is there should be a choice. It's the same problem that existed in the hijab case also. So, in the hijab ban, where the judgment is reserved, again, the case is that people who are supporting a hijab ban, let's not delve into the school part first. Firstly, just understanding this point, uh, people are saying that women are being oppressed, and that's why they are wearing a hijab. Ask them also, are they feeling oppressed? What if it's a choice? So this kind of this like a benign father, you will force your views upon people just because you know what is right, you know what is wrong. That is a problem. So there should be an element of choice there. That is more important. And beyond that, religion is always a very complicated matter. And frankly, if somebody does not believe in religion, we don't really see how entering a temple would liberate you. It would not. If I don't believe in God, it's all fun. It's all funny for me, right? And if I believe in God, it's very serious for me. So it's a very subjective opinion. And non-believers largely should stay away from it. The only element should be there should not be any damage to public order or health of an individual, right? Beyond that, it should be left for the parliament to decide after detailed discussion and deliberations. That should be your argument in your interviews also. Don't take a stand. You never know who the interviewer is, what is their own agenda or what is their own bias. Some people who are more tuned to being left wing, they may say that everybody should be allowed entry into temple. Now that is also improper because temples are not, or place of worship is not a picnic spot. Sadly, it has become a picnic spot now. So that is not fair. It's a place of worship where maybe feelings of lot of sections are attached. So we cannot treat that as a picnic spot. And again, what if he is a very conservative person who feels that religion is very important? So please don't reveal your personal point of view in the interview. That may not be appropriate. It can backfire. Clear? So the conclusion here is very simple. The court should refrain from doing all this. Let the parliament decide on these matters. And as far as the hijab ban is concerned, see, again, the hijab ban comes into picture with Article 19, that is 19(1)(g), a school's right to run, manage their own place. POTB. I have a right to manage, run my own profession, occupation, trade, or business. So, if in my school I don't want religious symbols, I have the right to do it. Now, you have to prove how that religious symbol is violating not Article 25, some other article. Because if you place Article 25 against Article 19, Article 19 wins. That is why this case, which have been filed in the Supreme Court now, Muhammad Arif Jamil case, here the ban on hijab is violating Article 19(1)(a), expression of an individual and right to privacy, Article 21. So in the courts, it's all a game of how you place your cards. Which articles can you prove are getting violated? So always remember one thing. Please don't ever claim Article 25. Article 25 is not absolute at all. Number one. Number two, every other fundamental right can simply kick out Article 25. So always try to, in your answers, also play around Article 14, Article 19, Article 21, the golden triangle of rights. It's very important. Are you clear? And beyond that, let's not delve deeper. A matter which is pending in the court, best left for the court to decide. Frankly, all these things, this entire uh, doctrine of essential practice. Now, judges are assuming a theological mantle, which they're not expected to do. Due to this, the opinion of the judge is now more powerful than an entire religion and is the voice as strong as that of God. Right? Uh, I think I would agree on Justice Chanchud's point of view here that what he said was that the judge abolishes an ancient practice merely with a blow on the table by a mallet. Mallet is that hammer that a judge has. So when a judge says order, order. So Justice Chanchud said, just by blowing a mallet on the table, you have abolished an ancient practice. And he further said that the test should be whether a practice subscribes to the constitution or not, irrespective of whether it is essential or not. Frankly, this should be the criteria. If any practice violates the dignity of an individual, then that practice should be removed, however essential it is. Okay, Ganesh, is hijab case? Yes, yes. In Supreme Court, a judgment came by a two-judge bench, 1:1, split verdict. So now the matter has been referred to a three-judge bench. So a three-judge bench will decide whether hijab is an essential religious practice or not, right? So uh, the people who are trying to prove that it is a part of essential religious practice, they say that hijab is mentioned in Quran and it is a farz of Muslim women to retain the same. Now it is best left for the courts to interfere, read the Quran, understand the meaning, etc., of what is covering the face, what is a veil, etc. Best left for the courts to discuss. Why should we enter in all those domains? That is Article 26. Now Article 27. Article 27 is a very simple article. It largely takes from the concept that you would also remember, jizya. Do you know this concept called jizya by any chance? Have you heard of this? Jizya. Yes. Remember the Middle India classes in your school days? What is jizya? Jizya was imposed on non-Muslims, zimmis, the protected subjects. Hafta wasuli. It's a protection money actually, which was imposed on all the non-Muslims who were called the protected people, zimmi. So think of it that now we will not have such kind of taxes. Freedom as to payment of taxes for promotion of any particular religion. Okay? No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in the payment of expense for the promotion or maintenance of any particular religion or a religious group. Meaning, you will not be asked to pay some tax, Hindu tax, Muslim tax, Sikh tax, Jain tax. No, no, no. Sorry. And the tax money being collected, that tax money will be used for only one religion's growth, development, etc. So this one more thing, a slight misconception. Can government use public money, taxpayers' money, to provide convenience to religion? Yes, it can. You will not be asked to pay a tax like Hindu tax. All Muslims now pay Hindu tax. All Hindus pay Christian tax. Now, this will not be imposed. But the government imposes income tax, companies have to pay corporate tax. Now, some small part from that huge tax and revenue of the government can be spent on providing convenience for religion. That does not violate this article. Are we clear? Everybody, the government has full right to spend some money to provide convenience to religion. This is a Supreme Court judgment also, Praful Goradia case. And you will see that various states spend money to provide convenience to religion. For example, Kerala every year spends around 50 lakh rupees for the Travancore Devasam Fund. Tamil Nadu, 13.5 lakh rupees is paid by Tamil Nadu government to the Travancore Devasam Fund. Government of India has spent 10 crore rupees in maintaining the infrastructure on the Amarnath Yatra route. Then Rajasthan government in their 2017-18 budget, they spent 39 crore rupees on Devasthan department. Madhya Pradesh government sponsors trips, senior citizens trips to Ajmer. In Gujarat, the Muslim imams are on state's payroll. Same goes for West Bengal. In Bihar, out of around 4,000 madrasas, over 1,100 are run by the state. In Karnataka, in their 2015-16 budget, around 16 crore rupees was spent on churches. In UP, 800 crore rupees has been spent on the pilgrimage to Kashi, Mathura, Ayodhya. 394 crore rupees is being sent for madrasas. So yes, the states are fully allowed to spend money to provide convenience for religion. But a specific tax will not be imposed on people. Right? Are we clear? No person shall be compelled to pay any special kind of tax, which would be called a religious tax. This is the limitation of this Article 27. Lastly, Article 28. Now, this article talks about how we cannot, or how there can be a limitation on religious instruction in schools and colleges, in educational institutions. So, freedom as to attendance at religious instruction or religious worship in certain educational institutions. Meaning what? We have three categories of schools and colleges now. Category number one, those schools and colleges which are completely owned and administered by the state. Those schools and colleges which are owned and administered by the state. Here, religious instruction will not be allowed. Now, let me just clarify one thing here. Religious instruction means how to worship. For example, how to perform a havan, how to recite the Quran. Now, this is called a religious instruction. If you are being asked or if you are being taught some chapter on Guru Nanak, some chapter on Jesus Christ, Ramayana, Mahabharata, that is not religious instruction. That is a moral science class. Difference. If you are being taught how to worship, that is called a religious instruction. Are we clear? So don't ever feel that if you are being asked to recite some Gayatri mantra, that may not be seen as a religious instruction. If you are being asked to say perform some Surya Namaskar, that could be seen as a part of physical activity. Clear? Then, in government schools and colleges, nothing. But those schools and colleges which are just recognized by the government or are getting government funds. Now, in those schools and colleges, instruction on religion may be allowed, but with the permission of the parents if the kid is under 18 and the kid's permission if he is or she is above 18. Clear? So here instruction allowed but with parents' consent or the student's consent if he has crossed 18. But The third one, those which are set up by a religious group only or some charitable trust. If a religious group is running a school or college, like say madrasa, basically, example madrasa, then what happens? Instructions are allowed there, and you have to mandatorily attend the classes on religious instruction. Like in madrasa, they will teach you how to study the Quran, what is mentioned in the Quran, etc., and you have to study it. So these are the three categories of educational institutions in the country. Akash, yes, that's true. It is not meant for individuals, not for groups. Gaurav, it is being challenged in the Supreme Court already, though these laws were made before the basic structure doctrine. So they have been challenged in Supreme Court already. That's it. We are done with the freedom of religion. A very simple question was asked. What can France learn from Indian constitution's approach to secularism? Firstly, tell me, what is the meaning of France here? France is the representation, or France represents Western model of secularism. Okay, so don't be confused. It just represents the Western idea, meaning strict separation. So, what can France learn from Indian constitution's approach? Very simple. When it comes to France or West, they follow strict separation, which means the minorities in these countries may not get any kind of protection. You are not offering any protection to the minorities, or within a religious group also. If let's say some section is suffering, if say women are suffering, men are suffering, you cannot offer them any protection because you say that's your personal problem. Whereas in India, we interfere, we protect the dignity of every group, every section, every gender, and the state has the power to make laws to even remove some practice. So this interference in religion, the principled intervention based on some principle of welfare, of reform, that is the beauty of Indian secularism. That's what these countries have to learn from us, right? So this is actually directly taken from that chapter 8 of political theory, direct question. So you have the point sufficiently mentioned to write a comprehensively decent answer here. Residential facility for students from particular categories is also included in this article. No, Parshram. That is for MEIs, not this. Next two groups of rights, very simple and easy. Cultural and educational rights, the rights for minorities. Articles 29 and 30. What is Article 29 and 30? Firstly, just remember again, Article 29 and 30 are meant for only Indian citizens. Yes or no? These rights are meant only for Indian citizens and not meant for others. So, protection of interest of minorities. Any section of the citizens residing in the territory of India or any part having a distinct language, if you have a distinct language, distinct script, distinct culture, you have the right to conserve your language, script, or culture. And we have already seen clause 2. Where did we see clause 2? Any idea? Do you remember? Article 29, clause 2. When did we see that? In the Champakam Durai Ranjan case, because the Madras Communal Government Order provided for reservation in schools, in engineering and medical colleges on the basis of religion and caste, which directly violated this article. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, sex, language. Religion, race, caste, language. On these grounds only, not RRCSP, but RRCNL. Clear? So this is Article 29. 9. And lastly, Article 30, rights of minorities to establish and administer their educational institutions. All minorities, whether religious minority or a linguistic minority, shall have the right to establish and administer educational institutions of their choice. Let me just clarify here. In our country, there are 6 such religious minorities in the decreasing order of their population. Muslims are there, then Christians are there, then Sikh, 1.7% population, then come Buddhists, 0.7%, then come Jains, 0.4%, and finally Parsis. These are the these are the 6 religious minorities, and they are on a pan-India basis. You'll be studying in your governance classes on the National Commission for Minorities, right? Now, language. Language based minorities are on a state basis, statewide basis. Second clause, the state shall not, in granting aid to educational institutions, discriminate against any school or college on the ground that it is under the management of a minority. So just because a school is a minority school or college does not mean that the state should discriminate and should not give aid. If the state is giving aid to schools and colleges, it can give aid to the minority schools and colleges also, and they should not be discriminated against just because they are run by minorities. Clear? Now, just to clarify, Supreme Court in a TMA Pi case 2003 has clarified. I think I saw 2 people mentioning this doubt also. In this particular case, Supreme Court has clarified that, see, Article 30 Clause 1 means every citizen, whether minority or majority. Nikhil and Gaurav, okay now? So, whether minority or majority, every citizen has a right to set up and administer their school or college. Simple. Number 2, very important. Just because you are running an MEI, a minority educational institutions, MEI stands for minority educational institution. Just because you are running an MEI does not mean that reservations can't be provided. Supreme Court said that yes, it can be provided. Are we clear on this? Every state has the right to provide some seats for reservation for people or kids from other communities also. Clear? So MEIs can also be asked to have some seats reserved. Point number 2. Now, a larger question here is that, see, what is the concept here? Concept is minorities, we have to preserve your rights, preserve the rights of minorities. That's very important. But we are talking about a school or college, an educational institution. Here, we need to ensure that there are some basic standards of excellence being met because we are referring to a future generation. That is why there has to be a balance. Yes, you have a right to preserve your culture, language, etc., but we need to ensure the maintenance of the standards of excellence. That needs to be met, that needs to be maintained. This balance is a must. Okay, And Supreme Court actually gave a judgment in 1989. This was this Hanfia Arabic College case in Bihar, where Supreme Court said that, see, you are being given a right to administer, not right to maladminister. The right is to manage your school or college. Don't mismanage it. That is why the state can prescribe admission procedure for aided. What is aided? Those who are getting money from the government. So state can prescribe admission procedure for aided MEIs to ensure prevalence of merit criteria. Secondly, unaided MEI. If any school or college is not getting any government funds, even they should have a very fair and transparent admission procedure. Clear? And lastly, very, very important, the state can prescribe minimum qualification for teachers and principals in your school and college. That's why I said the right is to administer and not maladminister. Supreme Court in 1989. This was the Supreme Court's norms on the minority educational institutions. Clear? So reservations can be provided. Then admission criteria can be decided if it's a funded MEI. If it's non-funded, then also the state can regulate to ensure that you follow fair and transparent procedure of admissions. And lastly, teachers and principals, the qualification can be given by the state. That is also possible. Are we clear? So we are done with all our fundamental rights. Now the enforcement of these rights remain. How to enforce these rights? After all, we have to enjoy these rights also. And if somebody violates your right, what do you do? Tell me. Article 14, 15, 16, 17, all these rights are getting violated. What do? You go to court, right? Enforcement. So let's take a lunch break. We'll firstly see right to property, what's the current situation. And once we are done, we'll come back to witnessing Article 32, the enforcement of the fundamental rights. Okay? Break, please. Come back at 2 or 2:05, no problem. Break till 2:05, and we'll begin our discussion on firstly right to property, and then the other remaining provisions. Atish, every citizen has to be cleared away together. So Ratish, what is this? Lot of auto corrects have happened, I think, in your question. Question again, please. Pradeep, it is by choice that people should convert, out of choice, not force. Akash, yes, of course. It can also invite vote bank politics, interference. That's also possible. That's a negative. Okay, guys, I believe that's all. Let's take a break, be back after the break, and continue our discussion further. Right to property, 19 is to... Sir, what are you writing? Right to property 19th is to require... Sir, have patience, frame your question properly, type it after the break, I'll address that. Don't worry. No hurry at all. Because I can understand what you're writing. Okay? Break, please, guys.